Some felons who have completed their active prison time will be able to vote in this fall's election. That's thanks to a split ruling from a three-judge state superior court panel. It's a complicated ruling, and it falls short of what the plaintiffs in the case had been seeking. Joining us now with some expert analysis is Jon Guze. He is Director of Legal Studies at the Locke Foundation. And Jon, this is a fascinating case, isn't it, about whether felons will be able to vote this fall?
Well, it's interesting for sure. There's lots of interesting aspects.
One of the things we should do is give a little background. This is a case called Community Success Initiative versus Moore. And the goal was to restore voting rights for all felons in North Carolina who have completed their active prison time but haven't completed their actual sentence. And the idea was that this was going to affect as many as 60,000 people in North Carolina, and it was part of a campaign called Unlock Our Vote. When you looked over the details of this case, what was your sense of the arguments made in this case?
Well, you know, they're spinning it as a win, the plaintiffs here, but I don't really think it was much of a win. They got something. And it's interesting. It's an interesting argument that the court makes of why they should get it. But most of the people that they were representing still aren't going to be able to vote because basically you do have to complete all the conditions of your sentence before you can have your citizenship restored and be able to vote. And that seems perfectly reasonable to me.
An interesting piece of this is that what is challenged is a particular law rather than the state constitutional provision in this case that says felons can't vote. It is a part of Article 6, Section 2 of the Constitution that felons can't vote. That is not what's challenged in this case. What is challenged is the general statute, North Carolina General Statute 13-1, dating from the early 1970s, that deals with restoration of citizenship rights. And the plaintiffs in this case said that law, almost 50 years old now, violates the state constitution in at least 5 different ways.
Well, let's go back for a second and clarify something. The Constitution doesn't say felons can't vote. It just says felons can't vote until their citizenship has been restored as prescribed by law. There was, even going back to the early 19th century, there was always an opportunity to get your citizenship restored and recover your right to vote, but it just wasn't automatic originally. Since 1971, it has been automatic once all the conditions of your sentence have been fulfilled.
And the claim in this case was that the law that sets out the details of that constitutional provision is unconstitutional because it sets some sort of differences between people who can afford to pay the costs of getting the fees and fines and other restitution. The people who could afford that are in a different class than those who can't afford to pay those costs, and that thus there is some unconstitutional problem here. 2 of the 3 judges bought that argument.
Well, they did in part. I mean, even there's a lot of different kinds of conditions that you can be released with a number of different kinds of conditions. And the only one that the court bought this argument for was the specific one that says you have to pay all the fines and fees associated with your sentence. They tried to make the argument, the plaintiffs tried to make the argument that you shouldn't take any of these conditions into consideration because somehow people who lack property or have less property are in an inferior class that makes it much harder for them to fulfill their conditions. The court only bought it with regard to the specific monetary payments, which there's some logic to that, I think.
Yeah, it was quite interesting. In fact, if we look at some of the specifics, the claims are from the plaintiffs in this case that this law that creates, from their vantage point, a different class of felons who have completed active prison time, that this law violates the state constitution's Article 1, which is the Declaration of Rights, in 5 different ways. And let's go ahead and tackle what the judges said about each of those. There were claims that the law violated the rights of assembly and the freedom of speech rights, all three judges in this case said, no, we're going to declare in favor of the defendants, the state. But then there's disagreement on the other three claims. On the idea of this going against the constitutional guarantee of free elections, two of the three judges said, well, we're not really sure. There's still a question of material fact here, so we're not going to issue an issue of summary judgment or a preliminary injunction. The case can go on in this respect. If they definitely had some sort of dispute about whether this affected free elections, that sounds like the right call. Don't issue a preliminary injunction in that case.
Of course, that's exactly right. This is just a preliminary motion. All that was decided here was whether or not there was going to be a temporary, not temporary restraining order, a preliminary injunction to prevent the state from enforcing this aspect of the law. The ultimate decision on all these issues will be made at trial later when all the evidence and all the arguments are put before the court. So this is only a very preliminary stage, and they're not going to grant an injunction unless the evidence is clearly on the side of the plaintiffs.
Now, in two other cases, two of the three judges argued that the evidence was in favor of the plaintiffs. And this is on Article 1, Section 11, which says there will be no property qualification for rights such as holding office or voting. And Section 19, which is the equal protection of the laws. In both of those cases, two of the three judges said, hey, the plaintiffs in this case are going to win. And so we're going to grant summary judgment in favor of them and give them a preliminary injunction allowing them to vote.
So it's my view is that even that's a bit of a stretch, and it'll be interesting to see how this ultimately plays out. But the strongest argument they had was the one on property qualifications. Not being able to pay fines and fees, you might not think really had much to do with property, but they're arguing that, well, if you don't even have enough property to pay your fines and fees, then you're disqualified. So it's kind of a slightly attenuated argument. The equal protection one is even weaker, it seems to me, because everybody's got, there's always going to be differences in people's ability to pay. And that means that if you buy this equal protection argument, it almost seems as if all fines and fees are suspect somehow, because some people can pay them easily and some people find it difficult. I would think that the better approach to all of these things is we want to make sure that our system of fines and fees is fair and sensible, so that we don't put people in a cycle where they keep ending up back in court and sometimes back in jail because they can't pay fines and fees. Fines and fees need to be somehow appropriate to the people's ability to pay. But to me, this seems to be something of a stretch to apply it here, although it's not necessarily wrong. I mean, obviously, if you can't pay them, then if you don't have enough property to pay your fines and fees, then that is a property aspect of the case.
Now, the two judges who agreed to issue a preliminary injunction because of that idea of the property qualification of Article 1, Section 11, and the equal protection of the laws, Article 1, Section 19, were Lisa Bell and Keith Gregory. Meanwhile, the third judge in the case, John Dunlow, didn't buy any of the arguments. He looked at the entire evidence and said he would grant summary judgment in favor of the defendants, the state, in every case. He basically said, I'm looking at all five of your arguments. I don't think there's any question of material facts here. Defendants should win. He doesn't buy any of this.
I tend to be most sympathetic to his position on this. I mean, if you think about it, North Carolina's position on felons voting is very generous. And especially since the law was changed in the 70s, because now you get your citizenship restored once you've completed all the requirements of your sentence. And there's nothing wrong with putting restrictions on people after the felons get punished. That's what the criminal law is for. Felons get punished. For a while, they can lose their freedom completely. There's no reason why they should get any particular aspect of their liberties and their rights restored automatically, certainly not before they've completed every aspect of their sentence. We're much harder on people when it comes to Second Amendment rights in North Carolina and nationally. It's much, much harder to get your right to bear arms restored than it is to get your right to vote. I think for most people, the right to bear arms has got much more practical impact than the right to vote. So I think this is kind of a tempest in a teapot, and I would have dismissed the case myself if it were up to me.
In fact, I want to quote one piece of Judge Dunlow's partial concurrence and partial dissent, because he really gets into what the rhetoric of this case involved as well. He says the plaintiffs, throughout their complaint, briefs, filings, and arguments, complain of North Carolina's, and he uses scare quotes, disenfranchisement scheme, disenfranchisement statute, and disenfranchisement of citizens. Ending the scare quotes, the disenfranchisement of which plaintiffs complain is in no way attributable to NCGS 13-1, which is the statute on restoration of the rights. No reasonable reading of the plain language of the statute could be interpreted to disenfranchise any person. Rather, the sole purpose of the statute is to provide a mechanism whereby individuals who have been convicted of a felony offense may be re-enfranchised. So it sounds like Judge Dunlow looked at these arguments and said, you're not even characterizing exactly right what this statute does. The statute helps people who have lost their rights to get their rights returned. It doesn't constitute some sort of disenfranchisement scheme. Do you think he saw this in the right way?
Yeah, I think he's exactly right about that. This talk about disenfranchisement is just political right now. It's become a buzzword, something to bash Republicans over. And the idea is that there's a nefarious scheme out here trying to deny people their right to vote, taking away people's right to vote. As he says, that's not what's happening here. This is about giving people back their right to vote once they've lost it, as they rightly and properly should have lost it because of committing a crime.
I want to turn to one last item before we wrap this up, and that is, even though 2 of the 3 judges agreed to issue a preliminary injunction, they limited it. The initial idea was to try to help as many as 60,000 North Carolinians who've been convicted of a felony but are no longer serving active prison time get the right to vote in this upcoming election. Judges Lisa Bell and Keith Gregory did issue a preliminary injunction, but they limited it to people who have served their active time, and the only reason that they have not yet had their rights restored is that they owe one of these fees or fines or restitution. That has to be a subset of the 60,000 people. That can't be all the 60,000 people. And that has to also be of only limited value, as you suggested earlier, to the people who were pushing for this restoration of felons' voting rights case in the first place.
I think that's right. It's a narrow ruling. I'm not sure what percentage of those 60,000 this will cover, but I'll bet it's a small number. And it's kind of a technicality. It's just because of the fact that we do have this constitutional provision that says voting rights can't be predicated on property, the ownership of property. And the court, in my opinion, went to a bit of a stretch and said, if you don't have enough property to pay even your fines, then you're being disqualified on the basis of property. So that may or may not be a sensible argument, but that's all they got. And it wasn't a lot, frankly. I think basically the law stands. You've got to complete your sentence and you've got to fulfill all the conditions before you get your full citizenship back and before you're allowed to vote. And that makes sense to me.
Seems to me that if you were, obviously one judge didn't buy any of this argument, but the 2 judges who did basically said, okay, we understand your argument. We are sympathetic to part of it, but we're not going to go all the way to allowing all felons who aren't now in prison to vote. Your argument doesn't lead in that direction. It only applies to this narrow, limited group that doesn't have enough money to pay the restitution or the fees to be able to get the rights restored. We'll help those folks, but you haven't proven your case that all felons who have served their active prison time should thus get these rights back.
Correct. I think that's what they said. That's what it means. How it plays out in terms of the number of votes that the Democrats pick up through this, I don't know, but it won't be huge.
Yeah, and it's also unclear to me at this point how anyone's going to decide who this applies to and who it doesn't. Obviously, if you're a felon and you haven't had your rights restored, it's easy to separate one group from the other. But how do you say, okay, you're a felon who has not served his sentence, but it's only because you haven't paid the fine? I'm not sure how that's going to be clear to voting officials.
No, I'm not sure that is going to be clear to voting officials, but I'm not sure that they're even going to care. I mean, these are requirements that I think are usually only enforced after the fact. If somebody gets caught, and if that happens, then they'll have to look at the facts, and if they fulfilled all the conditions apart from paying their fines and fees, then their vote will be legitimate, and if they didn't, then it won't.
Well, it's a very interesting case. We'll see where it goes from here. And as you alluded to, John, we don't know what kind of impact, if any, it'll have on the election. Jon Guze is the Director of Legal Studies at the Jon Locke Foundation. Thanks so much for your insights.
Thank you, Mitch.